Welcome to Call Frost First, Illinois Injury Law.
Hello and welcome back to Call Frost First, Illinois Injury Law. I am your host, Kevin Rosenquist, and today we're talking with attorney Kevin Frost of Clark, Frost, Zucchi about slip and fall injuries, one of the most common yet often misunderstood personal injury claims. Kevin's going to break down what really makes a case strong, how property owners' responsibilities in Illinois impact claims, and what evidence can turn a slip and fall into a winning case. Kevin, welcome back.
Hi, good morning.
So if you take a slip and fall call, what are the details that immediately might tell you whether a case may have real merit?
Just getting a handle on what happened, how it happened, where it happened, when it happened, getting just the basics of facts, because every slip and fall case is very unique, right? People don't fall the same way twice. There's foreign substances on the floor, so it could depend on the specifics of the store in which it took place. Did it take place at a major retailer? Did it take place at your local hardware store? And what specifically did you fall on, and why did you fall?
How do premises liability laws shape a slip and fall case, and what do you feel property owners legally owe to visitors or customers?
Sure. Here in Illinois, we're a pretty plaintiff-friendly state, but the one area of law that favors the property owners are premise liability cases. So as far as, I think a property owner has a duty to have a reasonably safe property. For instance, in Illinois right now, with the snow we've had out quite a bit so far, there is no duty for a property owner to shovel their snow in Illinois or to put salt down. Most store owners do it because they want you to visit their store, and they obviously they want you to be able to get in and out safely. But as far as a duty, there's not a duty to do it. Once you take on the duty, you have to do it properly. You have to be free from negligence. And so there are duties that develop along the way.
Does that change at all by county? Because I've always been curious about that. Whether or not a building owner or a store owner or whatever is responsible for making sure everything's safe in their general and outside of their building.
It can be by county. It can be by municipality. For instance, a city of Chicago could have an ordinance that requires homeowners, to actually shovel snow. It could be different in a suburb. It depends on specifically where you live. And then there's a state statute on residential removal of snow that actually protects the homeowner. So if you don't do such a good job, but you attempted to remove snow off your sidewalk, that prevents you from getting sued.
Oh, okay. So there's some sort of responsibility on the person to be careful, I guess, even when it's slippery out.
Yes,
Yeah.
absolutely. Yep.
Okay.
Yep. You was the walker walking in and out of a business. Yeah. I mean, you definitely have a duty, to be aware of the circumstances. There's a rule in Illinois called open and obvious. So if it's a big pothole, and you are not paying attention and you step in the pothole and break your ankle, it will be barred because the pothole was what's called open and obvious, right?
Okay.
So it's a tricky area of law, and that's why the facts of each case are so important to find out, the specifics of what actually took place.
What is the evidence you're looking for that typically make a slip and fall case stronger?
I think one of the most important things is do you have any documentation, right? Did you take photographs or video of the scene, right? For instance, if someone fell on a substance inside a store that was leaking from, let's say, an ice machine, you are going to want to be able to have proof that, yeah, like, look, my pants or my skirt were wet, and I took a photo of that, because after the fact, you're not going to have proof that took place. So the evidence of having those documentation is so important. I think, evidence of you actually notifying the store, right? And there's some sort of incident report filled out, so they can't come back and say, oh, well, we have no knowledge. We have no active or constructive knowledge that, Jane Doe was injured in our store that day, because nobody reported to us. So it's really important to especially if it's at a store, to notify someone of what took place and make sure that an incident report is filled out. And then lastly, I think the most important thing is, if you're injured, you got to seek help, right? You need to go seek medical treatment as soon as possible.
Do you have to look around for security footage too from other businesses and whatnot?
Sometimes, yes. Sometimes, for instance, let's say the footage from a business across the street could be helpful because it may have gathered a different angle than what that store had if that store even had anything. So yeah, it's definitely important in this day and age with stores, every store having almost a camera system. I mean, people on their homes have Ring doorbells, right? So like, it's important to gather information any way you can to get it to prove what happened.
What kind of questions or pieces of evidence are you looking at to determine whether a property owner was negligent versus the injury resulting from a person's own, perhaps, carelessness?
Well, that's why what took place is so important. For instance, in Illinois, we have contributory negligence. So if the injured party, for instance, is walking down the store and they're looking at their cell phone or texting someone and not paying attention, and they walk into a display that's pretty evident, right? Or let's say there was a cone put out and they didn't see the cone, the warning cone, because they're looking at your phone. That can create a problem, right? So obviously the less contributory negligent on our client, the better, and the more negligence on the store or the property, that's the better as well.
What are some of the mistakes that you see victims make that might undermine their chances of recovery?
Well, one thing is, I think, not gathering information, right? Not notifying the store, failing to take a photo, not if there's a witness there, not getting their name or contact information, right? Those are all things that you'd like clients to avoid doing. Making a statement like, "Oh my gosh!" Sometimes when people fall in a store, they're embarrassed, right?
Yeah.
And so they're like, and it's common. And people always say, "Oh my gosh, I'm so sorry, it's my fault." Well, you're better off not making a statement like that, because and I know people are always thinking like this, but someone could be reporting that, right? And said, the person said, "It's my fault." If it's not your fault, even if you're embarrassed, don't say it's your fault, right? Don't make any admissions like that to anyone, whether it's the store employee or an insurance company, frankly, until you've talked to someone like me.
Such a great point. The embarrassment factor, especially if you're slipping and falling outside, there's a whole bunch
Yeah.
of people all over the place. I mean, I went to school in DeKalb, so I remember people falling. Unfortunately, black ice is a big problem out there, So, but to your point, yeah, you don't want to, like, even if you're embarrassed, you don't want to say anything that could incriminate you later.
Yeah, and it stays with people. So people will call me, after the fact, and they're telling me the story, and I can tell, even if they don't, tell me they're embarrassed, that sometimes, frankly, they are embarrassed how they fell or what took place. But it happens, and obviously, it happens a lot of times because there was some error or errant situation took place at the store or the business, and that's frankly what caused you to fall.
When it comes to medical records and timely treatment, how important is that in a slip and fall claim? Because, Midwesterners are known to be a little bit like, I'm fine. Like there's like I don't know if it's a toughness or if it's just sort of just like I don't want to make a big stink or anything. I'll be okay. But can you talk about why that's a bad idea?
Yeah, absolutely. And you're right. That does happen a lot. And people sometimes come in and say the same thing, like, "Oh, I thought I'd be okay." And that's fair. If you get up, you're embarrassed and you want to get home, you want to get out of there after you hopefully you made some contact with the store. But wait and see, give it some time, but not a lot of time, right? So if later on that day or the next day, you're not feeling well and you have an injury to your knee or your shoulder or whatever it may be, you really do need to make an appointment or go see someone as soon as possible, because the medical records really are on your damages side are really the cornerstone of your case, right? If someone says in a deposition a year down the road, like, "Well, you went to the doctor on this date and then you waited 6 months, went to the doctor on this date," and you say, "Well, yeah, but my shoulder was bothering me through that whole 6 months." If you didn't go to the doctor, it's hard to prove that, right?
Yeah.
So that's why it's so important to document it and follow up and be properly seen at the proper physician's office, for your injuries, and make sure that there is a record of it.
So you said it's always very important to notify the business of the fall, of the incident. What should people say, and maybe perhaps more importantly, what should they not say?
Yeah, I think it's important. to tell them, what happened. I was walking down the hall, and the pop machine was on the left, and next thing I know, I fell, and my pants are wet, right? And I can see that there's some sort of spillage on the floor here, or if you walk by in a grocery store in the freezer section, and you're looking in that particular area, not looking at the ground in front of you, and next thing you know, you're on the ground, and then while you're on the ground, you see that there's some sort of leak from the equipment underneath the freezer. So that's why it's important to obviously to point that out to the store, and obviously then to again, I can't say it enough. I think pretty much everyone has a phone these days with a camera. Take a picture of it, right? It's true. A picture's worth 1,000 words, and that's going to help prove your case, because someone's going to say, well, I don't remember it being that bad, or I don't recall that, right? And if you like, yes, this is what took place. I think that's the most important thing. And again, what not to do? Again, don't say, oh my gosh, it was my fault. I wasn't paying attention, unless truly you weren't paying attention, and that was the reason for the fall. And that gets back to the contributory negligence issue.
Does a cone or a wet floor sign completely keep the store off the hook?
Well, it depends. It depends on if you throw out a wet cone and you don't and they walk away and don't clean up the mess, right? It's not like it's some sort of security blanket that allows them to say, oh, we had a cone up there. They still have a duty to clean up a mess or cordon off a particular area. A lot of stores now, they actually close down the entire aisles when they're doing work for safety reasons. And so that it just depends on, if you disobey that, went under a rope per se, that would be a problem for you. But just because a cone is up, it doesn't make them immune from liability. It just depends on the facts and circumstances.
It's really annoying when they close down a whole aisle, but I get it. I understand why they do it. But if I need
you
something
need that
in that
item
aisle,
in that aisle, right? Yeah, right. There's a reason why they do that. It's really for your safety.
Yeah, of course. Yeah. And I know that, but I'm just like, we talked in our last episode, we were talking about trucking accidents, and you talked about the insurance companies and how they handle things. How do insurance companies handle a slip and fall? Do they try to make a quick settlement in those situations? And it's similar to an auto accident?
They may, if they think it's if someone had a minor slip and fall, they may offer to pay the medical bills, and that's it. Or they may offer, like, if you went to an immediate care and say, we'll give you, $300. But I caution against anyone entertaining a quick settlement on a case, because you really don't know at that point yourself what the nature and extent of your injuries. Because let's face it, 2 days after the fall, it may, you may not have had your knee examined by a knee doctor yet, right? By an orthopedic doctor, who then you may have a long-standing problem. And if you thought after 2 days that it was just going to go away and signed off, there's just no reason for you to rush into that situation, because you sign a release, you're done, your case is over with, and you're done, and you're barred from going back and 6 months later and saying, hey, I tore my ACL in my knee, it's more serious than I thought. And then they're like, well, you signed a release, your case is closed.
I've heard stories of people, with car accidents, taking too long to act on things because they do think that they're okay, and then it makes their claim tougher later on. I could see that being even more so in slip and fall cases. Is that a fair assessment?
Yeah, it is, because again, people fall and they think, I got a bruise on my thigh, I'm going to be okay. I'll wait another week. And then you call and you can't get in the doctor for, let's say, a month. So that's why it's so important right away to make an appointment, because it may be a month out. Let's face it, if a month out you're 100% better, and luckily you've recovered and you really don't have an injury, you can always cancel an appointment. But if you wait too long, what happens is you have what's called a gap in treatment, right? So the accident happens on December 1st, and then you see, let's say, an immediate care facility that day, and then you wait 3 months, right? So what's going to happen is a sophisticated insurance company is going to say, well, there was Christmas, did you go sledding with your kids? How do we know that you didn't get hurt some other way, right? And just having that long of a gap in treatment just raises so many, it gives the insurance company the ability to question your injury and say, well, we don't know if it's really from the fall that happened on December 1st. So that's why it's important really to have the documentation that you went to the doctor.
Yeah, absolutely. That makes sense. Is there ever a situation? I mean, obviously, if you're super hurt, you call 911. But is there ever a situation to call the police like you would in a car accident, or not really?
No, I'm not really. I mean, I definitely have seen premise liability cases where someone's been injured enough that an ambulance, the EMTs had to show up and transport them to the ER. I can't think of a normal slip and fall where the police have been involved, unless I was involved in a case where there was a roofing collapse at a concert facility.
Oh.
And many people were injured, and that obviously had, because of the circumstances, police and fire were both dispatched, and it can be helpful because then you in addition to having like the EMS report, that there will be a police report where things are documented, photographs are taken. It just provides more evidence to present to the other side.
Yeah, you get that evidence, but yeah, I suppose especially if you're in Chicago, if you try to call the police because you fell outside of a building, you might not get a response. You might not get them to come out to that.
Yeah, that's true.
Yeah, understood. What do you say to someone who isn't sure if it's worth it to pursue a slip and fall case, kind of to your point earlier about the way people handle these with the embarrassment and whatnot?
Yeah, I think the most important thing is to call us, right? Don't be embarrassed. Well, we've heard all sorts of things over the years on fact patterns. So just call us and we'll review, we'll investigate. We'll examine any evidence that you have, and we'll go to the store. We'll look at it. We'll take sometimes take pictures ourselves of the scene as quick as we can, and don't be embarrassed, because if you fell and it's because of the negligence of either how they performed their job, or they were negligent in their policies that created a dangerous condition, then you shouldn't be embarrassed, and it's not your fault.
Mm-hmm. Yeah, important thing to note for sure. Yeah. All right. Well, that is it for us today on Call Frost First, Illinois Injury Law. If you or a loved one has suffered a slip and fall injury, reach out to attorney Kevin Frost at Clark Frost Zuki for guidance as well as representation. Visit clarkfrost.com to learn more. Don't forget to subscribe to our channel and leave us a review. We very much appreciate it. Kevin, always great chatting with you. Thanks so much for being here.
Yeah, thank you so much. Good to see you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.